Hi, welcome to your lecture on courts and the courtroom work. We're going to start first with jurisdiction. What is jurisdiction? What it means is which case can hear, or which court can hear a case, and what kind of case can it hear? Well, jurisdiction is defined as the legal authority of a court to hear a case. And how does a court get this authority? Well, it's conferred by either statute, so legislative creative law, or constitutional law. And there are four main types of jurisdiction. There's personal jurisdiction. Personal jurisdiction is the power of the court to bind a person. So if a person is sued or being prosecuted, how can the court get power over that person, which is jurisdiction? Then there's subject matter jurisdiction, the type of lawsuit. Geographic, so where is the court located? And hierarchical. Hierarchical, we're going to talk about more in a little bit, but it's the level of court. Is it a trial court? Is it an intermediate appellate court or a high appellate court? Let's break these down a little further. Let's first start with general jurisdiction. General jurisdiction is also called venue. Venue is basically where can a case be heard? Okay, depending on what kind of case we're talking about, civil cases generally are wherever one of the parties lives. That's where the case could be heard. If it's a criminal case, it is typically the county and state where the crime occurred. Hierarchical jurisdiction, that's what kind of court it is. And let me put it this way, if it's a trial court, only trial courts can be the court of original jurisdiction. Okay, and what that means is they're the first court to hear the controversy. This is going to be the guilt-innocence phase, the one party suing another party for one reason or another. That's the original jurisdiction. That's the beginning of a case, because a case is always going to start with the trial court. That's where you're going to have witnesses, a prosecution, a defense for criminal, a plaintiff and defense for civil, and you're also going to have witnesses, evidence, and then either a judge or jury making the final decision. That's original jurisdiction. So when you think original jurisdiction, think trial court. Next, you have appellate jurisdiction. Well, what does that mean? Appellate jurisdiction is the court above a trial court. And what they do is they determine whether or not the trial court has made any errors in its legal reasoning. So I kind of like to think of appellate courts as like a booth review. So if you're a football fan and the trial judge is going to be the ref on the field. But whenever the ref's call is disputed, it's going to go to a booth review. And the refs in the booth are going to decide whether or not the ref on the field made the right call. That's the same thing an appellate court does. An appellate court decides whether or not the trial court made the right decision. And appellate courts can do a couple things with a trial court's decision. They can affirm it, and by affirming it, that means they approve of what the trial court did. They can reverse it, saying, you know what, trial court, you made an error. Now you need to fix your error and go back and do it again. Or they can just enter a new judgment. Sometimes that happens when you're dealing with criminal cases. So think the landmark case Miranda versus Arizona, whether or not his confession was coerced because he should have been read his Miranda rights. The Supreme Court in that case completely entered a new judgment and threw out the case. Why? Because, well, double jeopardy, and a person can't be tried twice. So by throwing out the evidence, they essentially created a new judgment. Let's look at the different types of courts, because there are multiple kinds of courts. We're going to start first with the federal courts. And how were they created? Well, Article 3 of the U.S. Constitution created what? If we were in class, we would be having this discussion, but since it's online, I guess I just have to have that rhetorical pause. Article 3 of the U.S. Constitution only mentions one court, and it's the Supreme Court of the United States. So the U.S. Constitution in Article 3 created only one court, and that was the Supreme Court of the United States. Other courts were created, other federal courts were created by the Judiciary Act of 1789. And then the Courts of Appeals Act in 1891 created all of the appellate courts or circuit courts, which we're going to talk about in a moment. So let's dive a little deeper into federal courts. Okay, at the bottom, and they're not necessarily below trial courts, but they are their own entity. These are separate courts. They are military courts that have their own trial and appellate courts, the Court of Veterans Appeals, the U.S. Tax Court, the federal administrative agencies, and their boards also have their own court-like procedures. Okay, so the trial courts, though, in the federal level, these are the U.S. district courts. There are 94 judicial districts all over the U.S. Okay, in El Paso, we have several of the federal courts here in El Paso for the Western District of Texas. Okay, there's also the U.S. bankruptcy courts. We also have those here. The U.S. Court of International Trade and the U.S. Court of Federal Claims. Trial courts, again, are courts of original jurisdiction, and these are the courts in which the controversy begins, meaning one party sues another party or a defendant is put on trial for committing a crime. The mid-level are appellate courts. These are the U.S. Courts of Appeals, also known as circuit courts. There are 12 circuit courts, one U.S. Court of Appeals for the Federal Circuit. So there's 13 if you count them all together. And then finally, you have the High Court, which is the Supreme Court of the United States, also referred to as SCOTUS. So how does this work? If a case gets tried, and we'll just say criminal since this is a criminal justice course, defendant is tried for X crime and he's found guilty. He appeals to the appropriate circuit court. And let's just say the circuit court affirms the trial court's decision, meaning they approve of what the trial court did and allow his conviction to stand. The only place the defendant would have to go is to appeal to the United States Supreme Court. So let's pretend that person is Miranda. Miranda appeals his case that was tried in Arizona to the United States Supreme Court, and SCOTUS, in reviewing the Court of Appeals, who then reviewed the trial court in Arizona, finds that they were mistaken and throws out the case, and Miranda's conviction is overturned. All right, let's look a little bit more of subject matter jurisdiction for the feds. Okay, what types of cases are in the federal courts? Well, one, if the United States is a party, it is going to be a federal case. It's not going to be tried in a state court. Any kind of violation to the Constitution, so think Miranda, because Miranda versus Arizona was a state court. Okay, it was a sexual assault case in Arizona, so it probably should have stayed in Arizona. How did it get to the federal system? How did it get to the United States Supreme Court? Well, there was a federal question, and that federal question was whether or not his constitutional rights were violated. So any violation of the Constitution. If the case involves a law of Congress, the United States Code. If you have two parties suing one another and they're from different states. Or if two states sue each other, which has happened. Or if it's something like a bankruptcy or a patent, like a copyright infringement or trademark violation, those would also be federal cases. Anytime Congress makes a new law, that's just increasing the subject matter jurisdiction of the federal courts. Let's talk about the district courts. We've said a little, there are 94 of them. There are 667 district judges. These district judges are appointed for life. These judges are appointed for life. They also have helper courts, okay? And these are hired judges that run magistrate courts, and magistrate courts typically hear misdemeanors or lower level federal cases. They are appointed to set terms and not appointed for life. So magistrate judges are hired judges, appointed judges. Well, they're hired only for a specific term. So what is the jurisdiction of the federal courts? Everything that we just covered, federal questions, parties from another state, all of those things that we just discussed. Diversity, civil cases over 50,000, diversity of citizenship, anything that would be considered federal. All right, so let's look at the Circuit Court of Appeals. If you look at this picture, it shows you the different circuit courts. So you'll note that El Paso obviously is a part of Texas, and that means it is a part of the Fifth Circuit. Fifth Circuit typically tends to be very conservative, whereas the Ninth Circuit, which encompasses California, or which includes California, tends to be very liberal. The circuits that most people tend to follow are the Fifth, the Ninth, and the Second, which includes New York. Okay, courts of appeal, these are the second tier. These are the intermediate appellate courts. They're going to decide whether or not the trial courts, which would be the U.S. district courts, it would also be the bankruptcy court, and any of the other courts. They're going to hear civil and criminal matters. They're typically going to hear cases as a part of a 3-judge panel called an en banc, and they will make their decision based as a group. That takes us to SCOTUS, okay, the Supreme Court of the United States. Now, SCOTUS is a pretty cool gig if you can get it. There are 9 justices on the Supreme Court, and they are, just like every other judge, every other federal judge except for magistrate judges, they're appointed for life. They are the high appellate court, meaning that if they decide to hear the case, whatever their decision is, that decision is final. If they refuse to hear a case, well, then the decision in the intermediate appellate court is the decision that stands. Or if the case comes from a state court, meaning like it did in Miranda versus Arizona, where it came from the high court, the Supreme Court of Arizona, then had they refused it, then the Arizona decision would have stood. Okay, so SCOTUS can decide which cases it wants to hear. It's called the Rule of 4, which we'll get to in a sec. Okay, they hear and decide generally under 100 cases a year. In order for a case to get to the Supreme Court, a party has to file what's called a writ of certiorari, and it's a special plea to the court to hear their case. Now, the Supreme Court, I've said, has 9 justices, and in order for the Supreme Court to hear a case, 4 out of their 9 judges have to say, hey, I want to hear a case. Okay. What kinds of cases does the Supreme Court resolve? Well, state disputes, anytime there's a conflicting decision between the circuit courts. So right now, a hot topic issue right now is abortion. Texas has recently passed a law that gives private citizens the right to sue anyone who pursued an abortion or helped someone pursue an abortion after the pregnancy had reached 6 weeks. So I anticipate that going up through the system and to SCOTUS eventually. And any sort of constitutional questions like we've discussed. I'd like to show you this really cool website. It's not letting me. I'll go back and show that to you in a little bit. State courts. Let's talk about state courts. Every state has their own group of courts, and it is very similar to the federal system in that there are trial courts, intermediate appellate courts, and high state courts. Now, state courts are also courts of limited jurisdiction, meaning they only hear cases that originate from law within the state. Okay, they have, again, trial courts, intermediate appellate courts. They're going to handle a wide variety of matters. Most of the court cases that you hear of start in the state court. So when you think of most relationships that people have with each other, business relationships, marital relationships, property disputes, those typically are handled in state courts. There is also something in the state courts called trial de novo. That means that you can have pretty much a do-over for a court. So for instance, in family law courts, a lot of the elected judges have appointed judges that help them manage their docket. So for instance, if someone has their case heard with one of those appointed judges, they can decide that, you know what, they want a new trial with the elected judge, and that would be a trial de novo. They are generally courts of original jurisdiction, meaning these are the trial courts. So this is where the dispute is going to begin, with the witnesses, the evidence, everything that you think about when you think of a trial court. That is going to happen here. It can be civil or criminal. Civil would be, maybe there's a breach of contract or a child custody. Criminal, whether it be misdemeanor or felony for a state violation, or in some cases, violating a city ordinance. Courts of general jurisdiction typically can hear appeals from lower courts. So for example, if, let's say you get a ticket, and you get a ticket through the city of El Paso, you're going to have your case heard at the El Paso Municipal Courts. If you want to appeal that decision, it ends up going to a county court at law, and it becomes a trial de novo, meaning just a do-over in the higher court. State appellate courts, they work the same way. Okay, there are appellate courts that are civil, and there's criminal appeals. So in Texas, you have the Supreme Court of Texas, which hears civil cases, anything where people are suing each other for money, business transaction gone wrong, land deals gone wrong, all those kinds of things, as well as all family cases and juvenile cases. Juvenile cases will be appealed to the Texas Supreme Court. Criminal appeals are all criminal cases, all criminal state cases. So any violation of the Texas Penal Code, if you're an adult and you appeal, will go all the way up to the Texas Court of Criminal Appeals. Okay. States Supreme Courts are the court of last resort. They are the last stop before the Supreme Court. Can every case go to the Supreme Court? Like if you get a divorce and you don't like the way it ends out, can you appeal to the United States Supreme Court? Maybe. If there's a federal question, if there is something, if you feel a constitutional right has been violated or a state statute is maybe violative of the Constitution, it really is going to depend on that. But the likelihood of a family case going up would be very, very slim. One website I would like you to look at is to go to this www.texascourts.gov/about-texas-courts. This is going to give you a pictorial history of the Texas courts, and I'll make sure to post this for you as well. Court actors. Who's in the courtroom? Well, let's talk about who are these people that try cases. And maybe they're not trying the cases, but they're a part of it. They're a part of the trial process. So let's look at it. The judge. What are the judge's duties? A judge is there not only to be, first and foremost, they are the trier of law, meaning they decide what the law is and whether or not the parties are abiding by that law. A judge can also be a trier of fact, and that's when you have a bench trial or a trial by judge, where the judge sits not only as a judge to determine whether or not, what the law of the case is and whether or not the parties are abiding by it and rule on all the parties' motions and objections, but they're also going to be the trier of facts, meaning they're going to sit in the place of the jury and decide whether or not, in the case of a criminal case, whether or not the prosecution has proved the case beyond a reasonable doubt. Judges are also going to control jury selection. They are also going to control the flow of a trial. They are going to, for lack of a better comparison, they're like the referee. And the opposing teams, the prosecution and defense, or if it's a civil case, the plaintiff and the defense, they're going to control how the game is played, so to speak. So how do judges get to be judges? Well, for federal judges, all federal judges are appointed by Congress. They are nominated by the administration that's in power at the time, and they have to be appointed by the Senate. State judges are a little different. Every state is different. Some states have appointment by the executive of the state. Others have a system where it's it's merit-based, and there's a judicial council that nominate and vote people in. There's hybrid systems where judges are appointed, and then later on, the public gets to vote them in or out. So either the public can keep them or they can get rid of them. And then the appointment process begins again. Or if you're in a place like Texas, judges here are elected and they run on a party platform. So they run as either a Democrat or a Republican, and they are elected officials. One thing that all judges have in common is that they can be removed via impeachment. So if you have a judge that is not doing what they should be doing, they can be removed. Prosecutors. What is the job of a prosecutor? Well, I guess we should figure out who they work for. Prosecutors represent the executive branch. Okay, they are prosecuting a case on behalf of the government for which they work. So if they are a district attorney, they are prosecuting on behalf of the state. If they're a county attorney, they're prosecuting on behalf of the county in which they are living. If they're a city attorney, they're prosecuting on behalf of the city in which they live and work. One thing that you need to know about a prosecutor is that they are the arm of the government. They are representing the government who is prosecuting someone for committing a crime against the state. So when you see a case, it is not, defendant versus victim. It is the state of Texas versus the defendant. Okay, so make sure you keep that in mind. For states, all states have the U.S. has the U.S. Attorney General, which is the top lawyer for the federal government. States also usually have an Attorney General that's the head lawyer for the state. Next, you have the district attorney. Now, district attorneys, and depending on the state, you're going to have some different rules. But in general, district attorneys are the ones that are tasked with prosecuting persons who are accused of committing crime on behalf of the state. Most district attorneys are elected, and people that work for the district attorney are hired, meaning they are appointed. And district attorneys have to take an oath. Even assistant district attorneys have to take an oath to uphold the state in which they practice, uphold the state laws, the state constitution, and of course the U.S. Constitution. District attorneys have a tremendous amount of discretionary power because they get to decide, do I want to prosecute this case or not? A case will come across your desk and they'll wonder, well, do I charge this? Do I send this to a grand jury? Do I decline to prosecute it? Maybe they don't feel the police charged the right crime. Maybe they think it should be charged as a higher degree offense or a lesser degree offense. But make no mistake, district attorneys and any prosecutor who decides whether or not they want to prosecute a crime has a lot of power. and they can be highly influential. County and city attorneys, again, county attorneys, they work for the county that employs them. And county attorneys, at least in Texas, they have a little bit, or can have a little bit different function than a district attorney. So for instance, in Texas, county attorneys often represent the county. So they handle the representation and act as legal counsel to the local government. They also provide counsel to Child Protective Services. They can also act as prosecutors. For instance, the county attorney's office here in El Paso prosecutes juvenile crime, as well as misdemeanor environmental crime and misdemeanor fraud crimes such as theft by check, fraud by deception, things like that. And then the city prosecutors prosecute mainly traffic offenses and violations of city ordinances. So an example of a city ordinance would be like a curfew violation for minors. Defense attorneys. Now defense attorneys, there's a couple different categories. So we're going to start off with the public defender. The public defender is someone who is appointed for indigent defendants, meaning the person cannot afford an attorney. So under Gideon v. Wainwright, they must be appointed one. Okay, now there's different methods for appointing. Some counties have a contract model where it's just, hey, excuse me, Mr. Defense Attorney who has your own practice, I need you to work as an appointed counsel and the county will pay you. And they form a contract. Others have something called a wheel where defense attorneys are placed on, pretty much picture their names being like on spaces on a wheel. And as the wheel turns, their name comes up and it's their turn to take a indigent defendant. There's also something I wanted to bring up called pro se. And what pro se means is when someone says, you know what, I don't want an attorney. I want to just represent myself. You know, I never recommend that to anyone. I would say that's kind of like if you need your appendix taken out, would you do it yourself or would you go to a hospital and have a doctor do it? But some people still do choose to represent themselves. And if a court finds that they are competent and able to do so and they understand the risks involved, then the judge can allow a person to represent himself. There are also private defense attorneys, meaning they are paid by the client. So the client hires them and says, I would like you to represent me, and the client pays them. But one thing that is true of any defense attorney is their primary purpose is to zealously represent their client. And it doesn't matter whether or not their client is guilty or not guilty. Their job is to ensure that whatever prosecuting agency it is, whether it be the feds, the state, county, city, whatever it is, that their client's constitutional rights are protected. You know, when I represented people on the defense side, because I spent a lot of years as a prosecutor, and I was kind of bothered, you know, how am I going to do this if I feel the person actually did what they're accused of? And I had to stop and remind myself that it's not my job as a defense attorney to determine guilt or innocence. The job of the defense attorney is to make sure that the prosecution plays by the rules and that the client's or the defendant's rights are protected at all stages of it. Okay, and the defense attorneys have to provide the best defense possible within the bounds of the law. Okay, they're not held to as high of a standard as prosecutor. And I guess I didn't fail to mention this, but what is the purpose of a prosecutor? Well, the purpose of a prosecutor is to see that justice is done. Very, very different from zealously represent one's client as a defense attorney. A prosecutor's whole job, ethical duty, is to see that justice is done. Okay, not to seek convictions, not to see how many years they can get for a defendant in prison, but to see that justice is done. Okay, so going back to the defense. Okay, what else does a defense attorney have to do? Well, they have to provide a good defense. They've got to investigate the case. They have to prepare the defense. They have to, again, zealously represent their client. What about jurors? Jurors also play a role. Jurors decide the guilt or innocence, and in some cases, they will decide the punishment as well. They are picked from a jury pool or veneer, and picked is kind of a misnomer because they're not really picked. The way jurors end up on a jury, which we'll talk about a little bit later, it's more of a deselection process. It starts off with a very large panel or a very large jury pool, and then people are weeded out, and the first 6 or 12, depending on whether you're in a misdemeanor or felony, are the ones that will try the case, will sit on the jury panel. Okay, and how do they get weeded out? Well, they've got to go through a process called voir dire, which we'll talk about a little bit more later. Who are some of the other actors in the courtroom that you see? Well, you see the bailiff. The bailiff's job is to control, now the judge really controls the courtroom, but the bailiff is going to control the behavior of the courtroom. He's going to make sure that people are seated when they're supposed to be and that they stay where they're supposed to stay. And he's also there to help protect the judge. Court administrators. Court administrators typically don't sit in the courtroom. They usually sit in an office outside of the courtroom, and their job is to manage the court docket and really whatever other administrative duties the judge assigns. Court reporters. A court reporter's job is to take down everything that's said in court so that there is a record. The court clerk does not work for the judge. The court clerk works for either the district or the county clerk, and they are in charge of the court records and anything that's generated from the court, because those aren't kept by the court. They're kept by, if it's a county court, it's kept by the county clerk. If it's a district court, it's kept by the district clerk. So for example, in El Paso, your misdemeanor courts are going to, their records are going to be housed in the county clerk, and district courts, which hear felony cases and also things like child custody and divorce, they're going to house those records in the district clerk. Witnesses are also going to be present in court, called by either the prosecution or defense. Your expert witnesses tend to be regular court actors, as they get called a lot because that's their whole purpose. Then you'll also have lay witnesses. Lay witnesses typically are fact witnesses or persons who actually saw the crime or whatever it is that's being litigated, if it's not a criminal case. All right, let's talk about the overview of the criminal process. This chart is very, very in-depth, but it's pretty good. So you'll want to pause it and, look through this to see how many different ways a case can be diverted. Simply because a person is investigated doesn't mean that it's ever going to get presented to the prosecution. And even if it is presented, the prosecutor can choose not to proceed on the case. Or the prosecutor can take it to the grand jury, and the grand jury can say, you know what? We don't think there's enough here to indict, and it dies there. The path of the case can take on so many different twists and turns. It doesn't always end up in the same place. But let's just kind of go through these. Pretrial. When you think of a case, a criminal case, really you can divide it up into 3 phases: the pretrial, the trial, and the post-conviction, if we're talking about a criminal case. So let's look at pretrial. First thing you're going to have after the arrest and investigation is a complaint. Okay, and a complaint is the accusation of the crime by the police. So they've investigated a robbery, they've decided that, John Doe is the accused in that case, and then they will present it to the prosecutor. Okay, an accusation is typically followed by an arrest. Then they take them for booking, okay, where they take them down to their processing center, which is usually a county jail, and the person is booked, meaning they're fingerprinted, photographed, and their prints are run against, unsolved crimes in the system, and they're booked into jail. Well, what happens after that? Next, they have an initial appearance. This is their first appearance. Anyone that's arrested is entitled to see a judge. And that judge is supposed to determine whether or not there was probable cause for arrest. And typically at this point, bail is set. Next, there may be a preliminary hearing. Not all states have these, but at least most of them do in one way, shape, or form. A preliminary hearing is very similar to a probable cause hearing in that the defense attorney will say, you know what, you don't have enough evidence to show that you can hold my client. Oftentimes, early in an investigation, a defense attorney will ask for a preliminary hearing just to get the officers and some of the witnesses to testify before a court and get them on the record. And usually a state's case isn't ready to go then. So typically the prosecution will not bring charges or ask that the judge release the person immediately so that there's no need for a preliminary hearing. If the person is still in jail, there is a bond hearing, and the bond hearing determines whether or not the bond that was set is too high. Next, we will have the indictment or the information. Now, an information is for misdemeanor crimes. That means that the prosecutor reads the police report and they say, you know what, I agree that this was an assault, and they basically sign it, and that formally charges an adult with a crime. Juvenile is different, so we're just going to focus on adult. If it's an indictment, the prosecution has to send the case to a grand jury where they will need a majority of people to find that there is probable cause to go forward. And if the grand jury finds that, they'll issue what's called a true bill, which means that yes, we believe there's enough evidence to formally charge this person with a crime. If the grand jury doesn't feel like there's enough evidence, they'll do what's called a no bill, which says, you know what, you didn't bring us enough evidence and we're just going to throw this out right now. After a person has been formally charged by information for misdemeanor crimes or indictment by a grand jury for felonies, next they're sent to an arraignment. That is the first hearing after being formally charged. The purpose of an arraignment is for the court to advise the defendant of what he's being charged with and, again, his rights. And the defendant at this point will enter his first plea, which most of the time it's not guilty, and that just starts the pretrial process. Next, you have pretrial motions. This is a discovery period where the defense is trying to get as much information as they can, and sometimes they'll do things like a motion to compel where they tell the state, hey, we need A, B, and C, and you better get it to us. Other times they'll file what's called a motion to suppress, which is, you know what, we think that the warrant that you executed was invalid and we're going to try and throw out the warrant, which means if they can throw out the warrant, then any evidence that was recovered because of that warrant will be thrown out as well. And that usually leads to a dismissal. One thing that's very important during this discovery period is the case of Brady versus Maryland. Without going into the facts of the case, what Brady versus Maryland requires, and this was a SCOTUS decision, is that the prosecution turn over any and all exculpatory evidence. Any evidence that may show that the defendant didn't do it has to be turned over to the defense. If the prosecution fails to turn it over, the case will be thrown out later on. And in some instances, prosecutors have even been held in contempt, and in rare cases, they've been found to have obstructed justice or committed some other crime. So failure to turn over exculpatory evidence, which we just call Brady evidence, is very, very serious. That has to be turned over. Now, if the case can be plea bargained, it will. And so a defendant has a couple choices when it comes to pleas. They can plead not guilty, I'm taking it to trial, and make the state prove it. They could plead guilty, like, yeah, I did it. Or they could plead nolo contendere, or no contest. I'm just not going to fight it. I'll go ahead and just plead no contest. All right, let's talk about trials. This is actually one of my favorite little paintings. This is called Counsel Approach the Bench. So you see the two shark fins swimming up to the judge's bench. Anyway, I always thought it was cute. Even though it's kind of a knock on attorneys, I like it anyway. I'll own up to my sharkness, I suppose. All right, let's do an overview of the trial process. 3 parts: voir dire, the trial itself, the guilt, innocence, and punishment. Start off with voir dire. Okay, voir dire is actually pronounced voir dire. It is a French term, but because I went to school in Texas, everybody pronounces it here voir dire. But if you go to other parts of the country, it's voir dire. Okay, it is jury selection. Jury selection is a misnomer. It's not actually, you don't really pick your jurors. You deselect the ones you don't want. So when I'm picking a jury, I ask lots of questions and I find, you know what, I think this person's going to have a bias against my client. And again, you know, I've been a prosecutor and defense attorney, so my client's been the state. It's also been the defendant. And if I find that they have a bias against my client, then I usually tend to get rid of those jurors. Some attorneys like to use jury consultants, and these are professionals that study body language, that study how people answer. Some of them are psychologists, and they try and predict whom the jury is going to favor. You know, and a jury consultants, if they're good, you know, really, really good at recognizing human behavior, they can, and you can pick a good jury. That's closer to winning your case. How do you get rid of jurors? Well, you can make a challenge for cause. Objection, Your Honor, challenge for cause. And you would say that this juror has some kind of bias either against your client or the law. There are also peremptory challenges, and those are like free challenges. Be like, I don't know, Judge, he's wearing a red shirt and I don't really trust people that wear red shirts. And that's okay. You can strike someone on your jury for any reason whatsoever, so long as it's not for race or gender. If a person is struck, or if the other attorney believes that opposing counsel struck on the basis of race or gender, they can file what's called a Batson challenge and make the other attorney prove why they struck that potential juror. Trial. Okay, trial is broken up into this way. You have opening statements where each side gets to make their opening statement, which is not an argument. It is just a preview of the case and what they expect the evidence to show. The prosecution will go first with direct examination, calling all of their witnesses, and after prosecution's direct examination, the defense will have a chance to cross-examine the witness, asking leading questions. Like, you didn't really see who ran the red light, did you? Okay. After both sides have put on their side of the case with their witnesses, they will go to closing arguments, or actually jury instructions first. That should have been first, where the judge reads what the law is and what the jury has to do in order to render its verdict. Next, you'll have closing arguments where both sides give you their argument and what they think the ruling should be and how they expect the jury to rule. Sometimes when the jury goes back to deliberate, Sometimes they end up in a hung jury, which means that they couldn't decide. And in the states where a unanimous decision is not reached, you will have a hung jury, which means that the case gets retried with a different jury, and that's not a violation of double jeopardy. That's okay. Punishment. This is the phase 3. Now, for punishment hearings, you're going to do the trial all over again. Each side's going to have their own witnesses. The opposing counsel is going to get to cross-examine those witnesses, and you'll have opening statements, direct and cross, and then closing again for sentencing. Now, judges can decide punishment. On the state side, a jury, typically, most defendants will elect a jury to decide their punishment, but if they elect a judge can do it. On the federal side, the judge enters the punishment, and they have sentencing guidelines that they use. What happens if the prosecution loses? Well, they can't appeal. That would violate double jeopardy. But if the defense loses, then they can appeal. They can appeal through a direct appeal. And every state has their own appellate procedure. In Texas, they have 30 days to request a new trial. And once that's denied, then they can file an appeal to the Intermediate Appellate Court. So for El Paso, they would go to the 8th Court of Appeals, then to the Texas Criminal Court of Appeals. And if it's a constitutional issue or another federal issue, they can appeal it, if it's a state case, to the Supreme Court. If it's a federal case, it would go to the 5th Circuit and then to the Supreme Court. Now, an indirect appeal is, one example is a habeas corpus, where a person's in jail and they're not contesting the conviction. They're contesting the confinement, saying it's illegal to hold me here. Okay, and it's a challenge to the legality of confinement, not conviction. Okay, and it requires justification for not releasing. So it's, habeas corpus is its own animal, so to speak. That's all I have for you, and this was quite a long lecture. So thank you so much, and I'll talk to you next time.